minutes from the December 14th, 2020 meeting of the Rules Committee. Is there a motion? And when you do it, just say Judge X moves, that type of thing.
So moved, Judge Farley.
Is there a second?
Second, Avery Whetstone.
Thank you. Are there any proposed changes or modifications to the approval of the minutes as they were distributed?
Your Honor, Joe Del Campo, there is one change, please. I'd like to point out on page 2 in the third paragraph, third line down, it says the Connecticut Defense Lawyers. That should say Connecticut Defense Lawyers Association. So if we add association in there, that'll be correct.
That is a friendly amendment. Is there any further modification of the minutes? If not, all members in favor say aye.
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 Is there any opposition? That passes unanimously. The next item on our agenda.
Sorry, Justice McDonald, it's Judge Bellis. Can you note my abstention?
Your extension?
Abstaining.
Abstention.
I wasn't present at, yeah,
Got it.
I wasn't present at the meeting, so I abstained.
Thank you. The next item is 2019-014, proposal from Senator Looney and Senator Winfield and Representative Staffstrom regarding pretrial discovery in criminal matters. Attorney Del Campo?
Yes, sir. This was last considered by the Rules Committee on November 16th, 2020. Judge Gold, I believe, attended. The matter was referred out to Judge Gold again to contact Senators Looney, Representative Staffstrom, and Senator Winfield to broach with them the proposal as it stands now. Judge Gold had adjusted it somewhat and gotten other comments. He has reported to me, Judge Gold has reported to me that he was unable to receive comments from all the legislators. I believe he got with Senator Looney, but the other two he has not been able to contact. He asked that the matter go over, and he is hopeful that by February he can get all the comments together and explain to the legislators what the changes are from their original proposal.
Thank you. That's very helpful. Is there any objection to passing this matter until February? Okay. The next item is 2020-0110, proposal from Judge Stevens regarding amendments to section 13-14 of the practice book. Attorney Del Campo?
Yes, Your Honor. This was first on the agenda, I believe. I don't know, actually, right now. Judge Stevens, back in February of 2020, Judge Stevens put forth a proposal. It was commented on last meeting, and it was referred out. The CDLA and the CTLA commented. They were asked through attorneys Roberge and let me see. One second. Sorry. They were asked to go over it with Judge Stevens and to prepare a new proposal with language that was appropriate or agreeable. Judge Stevens did put that proposal forth. I embedded it in the current rule as that rule is set out, and that's what you have before you. I believe Judge Stevens may be at the meeting, but the proposal that you have before you is as agreed to by Judge Stevens with the CTLA and the CDL.
I'm looking, is Judge Stevens in the meeting?
Yes, I am.
There you go. Thank you. We can only see so many faces at one time. Welcome, Judge Stevens. Would you like to address this matter to the committee?
Sure, I'd love to. Probably should have done this when I was on the committee, but you know how things work.
Good to see you.
Good to see you too. I proposed this and then had conversations with Ms. Roberge and Ms. Arante from the Connecticut Defense Lawyers Association and the Connecticut Trial Lawyers Association, and we essentially discussed the issue, our differing views on it, and after some discussion came to an agreement regarding that which is before you at this time. There's the changes are relatively small. I can address them real quick. The first change of the existing rule is to indicate that the order that a court should issue in regards to a non-compliance with the discovery order should be proportional to the non-compliance. That is consistent with appellate court and Supreme Court authority that has reviewed this particular issue. So that's the first suggestion. The second one is to indicate that among the orders which the court can issue is an order of compliance. It's interesting that the rules did not explicitly indicate that that was a remedy which the court could impose, because it's ordinarily, in often cases, the very first order that a trial court will impose in the face of a failure to comply with one of the discovery rules. And the third change is that an order of dismissal, non-suit or default, should be a remedy as last resort. And again, as indicated in my initial proposal, that is to indicate expressly or explicitly in the rules that that is a requirement based on appellate court case law. And those are the changes.
Thank you very much. And I see Attorney Roberge is here, but before I ask if she has any comments, Judge Stevens, I saw that Judge Abrams raised a dissenting comment about the use of the term last resort. Did you talk to him about that, or do you have any insight?
I'm sorry, I did not see that. And so, no, I have not talked to him about that.
And was that language from case law? Is that what you said?
Yeah, that I just plucked that language out of the case law. I guess it could be phrased differently to indicate that an order of dismissal or non-suit of defendant default should be utilized after other remedies are considered or used. Maybe that might be a phrasing that might be more palatable than last resort. I think Mr. Amarante also had some issue with that phrase, but then did not press it when we got to the final draft. But that's where I got I did not make this language up.
Yeah, no, I'm sure. It does sound a little colloquial. I liked what you just said, that, you know, if all other available remedies have not resulted in compliance, the court could dismiss it. Would you be okay with changing it in that manner?
I'd have no objection to that whatsoever.
I'd rather not try to wordsmith this right now.
I would suggest to go just to the staff to work on the phrasing, consistent
Right.
with what you said, Justice McDonald.
I agree. Let's see if but when we get to this discussion, we'll hear from other members of the committee if that's acceptable to them. But Attorney Roberge, did you want to address the committee?
No, other than I'm available, Your Honor. We did have the last meeting in November. You asked us to myself and Attorney Amarante to see if we could agree upon language, and we thought it was appropriate to reach out to Judge Stevens and set up a meeting with Judge Stevens to discuss it amongst all of us. We did that. After discussing with Judge Stevens, we proposed some changes, sent it to Judge Stevens, and then there was an additional change. the remedy of last resort language, that is out of the, that is right out of the appellate court decisions. From plaintiff's perspective, I mean, I think that that's what it is intended to do. I know that it may be deemed, as Your Honor just commented, maybe colloquial, but it definitely states what it means. And I think that if it, the terminology speaks to exactly, I think what the appellate court decisions recognize, that an order of dismissal, non-suit, or default are extreme remedies, and they should be considered as a remedy of last resort. And I think the way that the new section, the way that the section now is with the changes, indicates that it is supposed to be proportional, that there are orders of compliance. In other words, there is a sort of, a level of different sanctions that can be imposed. But remedy of last resort is pretty explicit to explain exactly what it means. So I would request that language remain. As Judge Stevens mentioned, he didn't make it up; it came right out of the appellate court decision. So that's my comment with respect to that.
Thank you. Thank you. And Attorney Amarante is not on the call, is she?
I am here, Your Honor. Yes.
Okay. Sorry.
Good afternoon. That's okay.
Would you like to address this matter?
Sure. So as has been said, Judge Stevens and Attorney Roberge and I met and discussed this. I mean, we came up with a proposal. I agree, though, that with Your Honor and with Judge Abrams, that the as a last resort perhaps could be better phrased. But we are happy with the proposal as it stands as well. So, I mean, that was a compromise that we came up with, as the language about proportionality helps to some extent explain what it means to be a last resort, in my view, and incorporates more fully the case law. So, we're fine with it either way, Your Honor, from my perspective.
Thank you very much. Okay, so with that having been said, I would recommend, no pride of authorship here, but I would recommend, first of all, let me thank Judge Stevens and both of the attorneys for coming up with this. We always prefer to do things by consensus if we can. So I appreciate those efforts. But to address Judge Abrams's concern in subsection B5, I would recommend that we change it to say an order of dismissal, non-suit, or default, strike as a remedy of last resort, and insert if no other remedy has resulted in compliance. That would be my stab at trying to address Judge Abrams's concern, but I will open it to members of the committee to see if there are other viewpoints. Please make sure your microphone is muted if you're not talking, and use your the hand raising function. Thank you. I appreciate it. I saw Judge Bellis first.
Thank you, Justice McDonald. I think I might be more in favor of lifting the language from the appellate and Supreme Court cases. And that's the case law that Joe Del Campo had set out for us. So I don't know. I think it might be almost better to just add to the existing language, add to an order of dismissal, non-suit, or default as a remedy of last resort, and where it would be the only reasonable remedy available to vindicate the legitimate interests of the other party. So that we're not saying you have to go through each and every iteration, 8 different orders before you get there, but where it's a last resort and really it's the only reasonable remedy available, so that you don't have to go through every remedy. But again, that's just picking up the language from the existing case law.
Thank you. And why don't we just run the table for anybody who has comments? I liked Judge Bellis's comment, though. So next is Judge Cobb.
Yeah, I mean, my concern about this has been what Judge Bellis mentioned, which is I don't believe that, I mean, the way it's originally sounds and the language that you suggested, Judge McDonald, does make it seem like the court would have to go through each and every option available before it finally issues a non-suit or a dismissal. And these things happen in a variety of ways when we're addressing discovery issues. And it certainly would be expensive for the opposing party, whether it be the plaintiff or the defendant, and a bit of a waste of time to have to go through every single iteration. I actually think that by including the language that it be proportional and then including the list of possible remedies is all we need to do here. I mean, the case law is clear as to how to analyze it, and we're all doing that. And I don't want anybody to think that I have to do every single one first before I finally dismiss it. So I would recommend that we just it should just end at an order of dismissal or non-suit or default, period. Because proportional to compliance, I think, does what it needs to do. That's the key, I think, to that case.
Thank you. Judge Farley.
I agree with Judge Cobb, and I think that when you look at the cases, yeah, the cases do say last resort. They say all the things that are being mentioned here, but really what they do is they set out a number of different factors that a court should consider when, coming up with a proportional remedy. Yeah, for example, one of them is whether there's been prior noncompliance. And I think to try to pick up all the factors in a neat little phrase is a little bit different or a little difficult. And I think the proportionality, which also directly pulls in the case law, is really all we need.
Are there any other comments? Judge Bellis, I see you shaking your head. Do you agree with those comments?
I absolutely do. I agree with Judge Cobb and Judge Farley. The only reason I was adding to the last resort language is because I thought that was sort of a compromise between attorneys Roberge and Amarante, but I would 100% be satisfied with the proportional to the non-compliance language and just remove the remedy of last resort language.
Okay, since it was the suggestion of Judge Cobb, I will take that as a motion to amend the language to insert a period after default in B5 and remove as a remedy of last resort. Is that right, Judge Cobb?
That's right.
Is there a second?
Second, Judge Bellis.
Is there any discussion on the amendment? If not, all in favor, say aye.
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 Are there any opposed? Okay, so as on the motion to approve as amended, any discussion? All in favor, say aye.
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 Is there any opposed? That passes unanimously. And again, thank you to Attorney Amarante, Attorney Roberge, and certainly to Judge Stevens for your work. I appreciate that. The next item is 2020-012. It's a proposal from Attorney Megan Wade and then the Connecticut Bar Association for an amendment to the rules of professional conduct related to Rule 8.47. Attorney Del Campo, would you like to try to pick us up where we left off?
Yes, sir. This came in originally back in June, I believe at the meeting after the public hearing from Attorney Wade. It went over to September. Attorney Wade was asked to coordinate her proposal with the Connecticut Bar Association. They did do that. Ultimately, Attorney Wade withdrew her proposal, and in substitution, therefore, was the proposal that you have today, which is the proposal from the CBA. That came in September, at the September meeting. And at that point, comments were solicited. We've been soliciting comments for some months now. We have about 60 that you've had to review in this package. And that's basically where they're at. There was a deadline of, I believe, December 4th for these deadline comments. That came and went, although there was a case that came out just after that date, which subsequently we did allow people to comment on. That's the Greenberg decision that's in this package. And there are some comments on that decision. It's not been yet considered on its merits. I think that's what you have in front of you now.
Thank you very much. Let me just make an observation. I know that this proposal has generated a lot of interest. I would suggest that this is not the constitutional question, as it's been bandied about, is not something that we as judges are adjudicating here. That would be done if this proposal was adopted and approved by all of the judges of the Superior Court. That question would be addressed in an appropriate forum where it could be properly litigated and analyzed and argued and adjudicated in a adjudicative forum. That's not what we are. We are a policy and operational forum for the branch and for the practice of law. So I approach things like this that we would be making a decision about the merits of it in terms of its operational effect and the supervision of the practice of law, and that if and when it gets adopted, then there would be an appropriate time and an appropriate forum to address other questions that are not within our purview to do in this kind of very loose format of just having comments submitted. So I just wanted to frame this discussion with those preliminary thoughts, and I'm certainly willing to hear other comments from members of the committee. So just to on the big picture first, let's see if there are any comments from members of the committee. If so, please raise your hand. Judge Cobb.
Yes, Justice McDonald, I do agree with your comments and the role of the committee. I would say this, though, that I certainly wouldn't want to enact something that could obviously have issues with it. And so I guess the comments that I was most interested in reading through them all were the ones from Michael Bowler, which talked about some of the concerns that the statewide grievance committee had in how it would apply it, because some of the language was vague. And so that is my concern today, is making sure that if we agree that this kind of a proposal as a policy matter is a good one, we want to make sure that it is tight enough that whoever's got to enforce it is able to do so. So I want to make sure that we're being clear, and I hope that I'm being clear in those comments. Thank you.
Thank you. Yeah, that was actually step 2 in my analytic format. I read those comments as well, and you know, I mean, it's our state law is pretty clear on what discrimination and harassment is, but I have no problem in trying to make it all clear in one area for this proposed rule. And so I really appreciated the comments from Attorney Bowler and the Statewide Grievance Council office. So I think some more work would have to be done on this to address those concerns. I saw he had a link to what the main bar did in terms of trying to define some of those terms. I did not have an opportunity to look at how they handled that. But why don't I keep my mouth shut and turn it over to Judge Bellis, who has her hand up.
I just had an inquiry, and I echo Judge Cobb's comments, and I also gave great deference to statewide grievance concerns and comments, and I just wondered, and I don't think I saw it in the documents which went through Triple F, I believe, but do we have something from disciplinary counsel or Attorney Staines' office that I missed? Because
Yes.
I missed it.
Yeah, well,
Okay.
it was the last, I think the last one, Triple G.
Right.
Okay, then was that an add-on? I didn't see it.
My recollection of it is that it was basically subscribing to what the Statewide Grievance Council's
Okay.
comments.
All right. Then that addresses that issue. I guess the other sort of question I had, I look at this, we have a unified court system in Connecticut where it's unusual or a very small state, and we have, a workable disciplinary system. And I just wondered, if that makes a difference in this analysis at all, as opposed to states like California, which has a total different setup. And I just wondered if I didn't see that addressed anywhere. And I just wondered if that's something that Attorney Bowler would be allowed to address, or Attorney Staines. I just think we're somewhat unique, given that we have we're the kind of state, almost all the lawyers appear before you, regardless of what end of the state that they're at. So it makes it a little easier for us as judges, and I'm sure for grievance and disciplinary counsel to engage in the supervision of the lawyers. So that's my inquiry.
And I will certainly entertain any additional comments from members of the committee. But what I was going to suggest is doing this back and forth is not the most efficient way of trying to accomplish this. What I was going to suggest is that we ask Attorney Bowler to get into a separate meeting, probably with Attorney Stovall, who I see on the call, and representatives from the Connecticut Bar Association, to see if we can address some of the concerns that Attorney Bowler identified. I'm not certain I agree with the comments that there are other rules that sufficiently cover the landscape that would be within the scope of this proposed rule. There are certainly, from the comments we've received from the questionnaire that was sent out to all of the lawyers, there are a lot of other scenarios that have apparently transpired that would not fall within the scope of any other rule. So I think we do need to entertain a more broad question, but Attorney Bowler's comments about the lack of definitional precision were well taken. And so that would be my recommendation. And we'll see what Judge Farley has to say.
Well, I just want to add a couple of things. If we're going to have people working on this, first, I do agree that there's a good reason to adopt a rule addressing discrimination and harassment directly. I thought that the examples that were listed in the Statewide Grievance Committee submission really illustrate the fact that most of the disciplinary actions that have been taken are being taken on actions that occur in a courthouse or in litigation. And obviously, one thing this rule would do would be to extend beyond the courthouse. So that's one reason why we need to go there and consider this rule. The other thing I wanted to add on the drafting is, and maybe this is subsumed within what Attorney Bowler said, but I also agree with what the Hartford County Bar Association said about so much substance being put into the comments. And I would like to see some of the substantive points that are put into the comments lifted up into the rule itself, so that I think the rule would be stronger and clearer.
Okay, and by the way, I would certainly want Attorney Del Campo or members of his staff to participate in these meetings to help facilitate drafting. But if we're trying to frame a charge, if you will, to this working group to hammer out these details, do any other members of the committee have comments that they would like to make now so that Attorney Del Campo and others would have the benefit of our preliminary thinking before they try to hammer out the details? Okay, I don't see anybody else raising their hand who's on the committee. And I wasn't suggesting that that was an exclusive list of who, it has to be a sufficiently small number of people that work can actually get done with a sufficiently large enough number so that many viewpoints are at the table or in the conference room, if you will. So I would suggest that Attorney Bowler, Attorney Del Campo, Attorney Stovall, and a couple of representatives from the bar associations get together and try to work these details out. I'm sorry, Joe, please remind me who at the CBA was taking the lead on this? The substituted language?
So I believe it's Mr. Thomas was the one that ultimately submitted it through Mr. Chapman.
Okay.
And I think Attorney Wade, Attorney Stovall, Attorney Ceresi, they were on copy here. So
I mean, I'm not going to be sitting in on these, so I will leave it to you, Joe, to make sure that unless there's objection, make sure that there are sufficient, the appropriate voices from the bar associations involved in the discussion.
Okay.
Is there any objection to proceeding in that manner at this time? And again, that would be hopefully the last part of this before we have something definitive that we can discuss and potentially vote on. Is there any objection to proceeding in that manner? I don't see anybody raising their hand. Okay, thank you very much, ladies and gentlemen, on that. The next item is 2020-20. The proposal from Teco Kim to adopt a code of conduct for judicial employees. This is the first time it's being considered. I don't know if everybody's had a chance to look at the communication from Mr. Kim, but I would like to not discuss this without having first submitted it to the Chief Court Administrator for the Chief Court Administrator's office to solicit input from the Human Resources Department or Division and the Labor Relations Division. Even entertaining a code of conduct for employees would presumably impact labor relations matters that we should have the benefit of that before we spend any time on this. Is there any objection to doing that? Okay, is there anybody else that in the committee's view should have this referred out to them before we consider it, or is the Chief Court Administrator's operation sufficient? I see no hands. Okay, we will proceed that way. Is that clear, Attorney Del Campo?
Yes, sir. Thank you.
The next item is 2020-21. It's a proposal from Judge Albus to amend sections 3.1 and 3.3 concerning appearances and adding email addresses. Attorney Del Campo?
Yes, that was last, let's see, that was last considered last meeting. It was referred out after discussion. It was tabled until this meeting and referred the proposal to the Connecticut Bar Association, the Connecticut Trial Lawyers Association, the Connecticut Defense Lawyers Association, and also to various legal aid organizations to have an opportunity to comment. The comments that we received, I believe, are from the legal aid, various legal aid organizations. I believe Judge Albus is also at the meeting today, and Attorney Shea is in attendance as well, representing the legal aid organizations with their comments.
And let me turn it over to Judge Albus, see if he has any input.
Thank you, Justice McDonald. I did review the letter submitted by Legal Services. Just a couple of comments. One is that much of the letter concerns the need to address the needs of people without necessarily the resources to easily participate in video hearings, and I agree with that. When we do get an email address from a litigant, we send notices with links to the branch website with information about how to participate. There's a phone number to call if you are not able to participate by video. The letter also addresses the language I included in my letter to the committee about possible changes to the form instructions. And I didn't mean to be conveying that I was asking this committee to approve that language. I only offered that to show that we had considered, the chief administrative judges had considered the possibility of either someone not having an email address or someone having one but not wishing to disclose it. And I just offered that suggestion to show that I had discussed the matter with court operations, that they were aware of that, and that some language like what I included in the letter might become part of the form after review with legal services. But that might change. It might be a different set of instructions. I really was only asking for the rule to be amended to include the email address. There was a request or a suggestion in the letter from legal services that that language be changed to specify that you only have to provide your email address if it's regularly used by you. And I would oppose that additional language. And the reason I would oppose it is that, especially right now, this is the way we have to conduct our proceedings. And if someone has the ability to have an email address and a link that would allow them to participate by video, even if they don't normally use email regularly, they have the ability to do it. And when you're involved in a lawsuit, you have a certain obligation to provide ways for the court to contact you and to allow you to participate in proceedings. And I'd be reluctant to support a rule that sort of gave someone the option to say, well, I don't really use my email that much. I don't want to give my address. I think you have an obligation. You know, you may not usually come to court either, but when you're involved in a case, you have an obligation to do that. So I do think we have to be sensitive to making the system accessible to everyone. But I don't think that being a regular user of an email address should be a condition for being expected to participate remotely, any more than using the mail should not be an alternative if someone says, I really don't get to my post office box that often. So I would oppose that change for that reason.
I would point out that people create single purpose email addresses all the time, so that somebody could create a separate address for just their court related business. Okay, I appreciate that. Is there any other discussion or questions from Judge Avery Whetstone?
I've been doing the remote hearing since we started in, I think, April, Mike, if that's correct. I've only had one occasion where somebody who was a non-English speaker did not have an email address. Everybody else across the board has had an email address for the court.
Thank you. Are there other questions from members of the committee? I saw that Attorney Shea has her hand raised. I would recognize her now.
Good afternoon. This is Giovanna Shea from Greater Hartford Legal Aid. Thank you for giving us the opportunity to submit a comment and to join you this afternoon. I see in the chat that Shelley White from New Haven Legal Assistance, Darren Pruslow from Connecticut Veterans Legal Center, and also Greg Kirchner from Fair Housing Center have joined, and possibly others as well. We absolutely understand the necessity of the court having an email address if there is one to be obtained for the reasons that Judge Albus has outlined. And it may be working well for many people, but our position, our vantage point at Legal Services, particularly with respect to self-represented folks who we can't assist, and also facing what looks to be potentially a very difficult eviction surge when the moratorium ends, including folks who are defendants and who are not brought willingly into court, is that we have concern about very indigent people who, even if they do have an email address, may not be able to access it on a regular basis. That could be because they lack adequate internet, or in terms of accessing Teams, there may also be an issue with having an adequate device to participate with a camera. So our suggestion with respect to the text of the practice book provision was that folks would be, as self-represented litigants, required to provide an email address if one is in regular use. I suppose we could talk about a different language, you know, if one is available to you or if you are able to access one. So it's not so much a matter of personal preference or Ludditism as it is, you know, do you have the ability on a device with internet to check that with sufficient regularity that you receive critical notices? I think that is the question we would ask the committee to consider. Those of us on the call and our colleagues really have met folks who have only a flip phone, who have no internet, and it can be a very difficult situation for those people, even if the court's new remote procedures are working well for many. So we've suggested that language for the sections of the practice book that relate to self-represented people in terms of what they would be required to provide on an appearance form. And we also had some suggestions for the forms, for the appearance forms. And I understand Judge Albus's comment that that's not necessarily to be decided by the Rules Committee, but in thinking through how the judicial branch might request this information from folks to really get a sense of, are there going to be problems with self-represented litigants participating via Teams adequately? We proposed some questions that might really get at that in terms of, do you have internet access? Do you have a device that has a camera and the ability to connect with the internet? Do you have an email address that you can check every day, remembering the very speedy pleading schedule, for example, in the summary process context? If you answered yes to all the above, please provide your email address, recognizing that you could, as Justice McDonald stated, set up a single-use email address. If you answered no, please contact the clerk's office for information on alternative ways you may access remote video proceedings. And in our comment, we noted that HUD has asked public housing authorities that run informal administrative hearings to check on residents' ability to participate in remote video hearings, to provide alternatives, including in-person hearings when they cannot participate, to even provide loaner devices. And if that is what HUD is asking housing authorities to do for informal administrative hearings, we feel that, you know, is what the judicial branch should do in Superior Court. We don't think participating by phone is a really phone only without a video camera is a good substitute. And again, that may be beyond the scope of what the Rules Committee will consider, but because this seemed like an important moment when the judicial branch would begin seeking to get and require email addresses from self-represented litigants, we wanted to raise up these issues about the digital divide and try to initiate that conversation. So thank you, and I'm happy to answer questions if anyone has any.
Sorry, I was on mute. Before I recognize Judge Bellis, let me just say that I hear your comments, Attorney Shea, and some of them are well taken. I'm trying to figure out how, I don't know that we're going to be able to craft a rule that is going to address all of those variables that could or may happen to some people. And so I'm wondering if it wouldn't just be easier if we added something in that said, unless otherwise ordered by the court, provide the email addresses. And that would allow a litigant to seek alternative orders from the court depending on his or her particular circumstance. Why would that not be the easier way to try to address your concerns without making the language so cumbersome?
Well, Justice McDonald, with respect to the language just of the practice book provision, we've only suggested that they be required to provide an email address if one is in regular use. So I suppose when you're talking about making language cumbersome, you're thinking of the appearance form and the series of questions. Is that what you're referring to?
Correct.
So with respect to your question, of course, I want to discuss with my colleagues in legal services, but my initial personal take on it is that it would be important to provide information to self-represented people about how they could seek an order of the court that they be allowed some alternative. Otherwise, you might have problems with access even in such an order, if I'm understanding the court's proposal.
Okay, thank you. Judge Bellis?
Thank you, Justice McDonald. So I just want to clarify my understanding here. So the email, unlike attorneys who give the email address and then agree to serve other counsel with the email address and they get notices from the court via email electronically, self-represented parties will still get the paper notices from the court that well in advance of the hearing. So they'll have their hearing date, they'll have their notices. And so the email address is not to send all the notices and decisions and to have service from the other side that way. This is simply for the court to send the link for the Microsoft Teams meeting as I'm understanding it. And so if my understanding is correct, there would be no reason once a self-represented party got their paper notice of a hearing via Microsoft Teams with the date of filing a motion for continuance or whatever appropriate motion there is, as they would for any other reason, simply, indicating that they don't have access to email on that particular day, and to ask for a continuance or to ask along the lines of what you suggested, asking for a court order that it be done in a different manner. So I just want to make sure my understanding is correct, that we're just talking about email just for the purposes of the link to the Microsoft Teams and not for all the other notices from the court and pleadings from the other side. So I wonder if that's something that Judge Albus, if you would permit, if he could answer that, just to make it clear.
Of course, Judge Albus.
Yes, that's exactly right. And that's an important point. Now, a self-represented party would have to affirmatively agree to accept notices electronically. Giving the email address alone does not do that. It's just for us to have on hand. And Judge Bellis is absolutely right. When a hearing is scheduled, there still would be two steps. There'd be the same order scheduling the hearing and being mailed to most self-represented parties, unless they had chosen otherwise. And that notice would tell them that they will be getting their instructions by an email with a link. And it will probably still say, if you can't participate by video, then call this number or whatever they should do. It would just eliminate the step that we have now, which is we send out that notice, and the notice says, we're having a hearing by video. Please give us your email address within 5 days so we can send you the link. We would already have the email address. So this is not intended to replace mail notices. It's intended to eliminate that middle step. And we would always give parties the opportunity, if they couldn't participate by video, to try something else, including an effort that's underway to set up kiosks in the courtrooms, in the courthouses rather, for parties who just don't have the device they need to come in and be able to participate remotely. So all we want is to try to get the email. Sorry.
Go ahead.
That's right. May I respond, Justice McDonald?
Yes, go ahead.
So I think that was the distinction that's in my mind. So we have three separate things, right? We have the notice from the branch with court decisions, court orders, dates of hearings. And so while it's electronic for attorneys and they have to go into their email to get all these notices, that's not the case for the self-represented parties. Then we have the service, right, where people can, self-represented parties can opt for email service from the other side. They don't have to do it, and neither do attorneys for that matter, although most of them do. And then we just have this limited email use just to send the link for a hearing that they're going to have. A self-represented party will have already been notified well in advance by snail mail. So I'm not sure if that addresses the concerns that were raised. And the only thing I would add is that maybe we can, Judge Albus, in his role as Chief Administrative Judge for Family, can work with case flow just to make sure that there's enough lead time from when the notices of the hearings are sent out snail mail to give the self-represented parties sufficient time, especially if they're not opting to e-file, to file a paper motion for continuance or a motion, whatever motion would be appropriate to have sort of an alternative type of hearing. So that's all I have to say. Thank you.
Thank you. Judge Albus, did you have anything else to say?
No, although I will say that we do give ample notice. Most hearing notices go out a month or more before the hearing date. And we ask people to give us email addresses within 5 days, but in reality, it's not unusual to get an email address the day before or the morning of the hearing. And when we get that, we send out the instructions right away. And we try to do everything we can to help people participate. I don't know if there'll always be more than a month notice, but that's been the practice so far.
Okay, I will just briefly allow Attorney Shea to comment.
Thank you. That's very helpful, Judge Bellis and Judge Albus. I guess our concern, or at least my initial concern, would simply be, and I don't have one of the notices in front of me now, but I think it would be important for the notice to indicate if you don't have the ability to access email, call CaseFlow or call the clerk's office to seek an alternative. In a very plain language way. I think that would be very helpful. And for the practice book to leave the text of the provision, to leave some wiggle room for folks who really are not able to access email, whether that's unless the court orders otherwise, or some language email if you were able to access it, or something of that nature. Thank you.
Okay, thank you. I mean, the logistics of this is really not something that is going to be hammered out in a rule. I think it's Court Operations is the one who develops these forms, and I'm certain that having heard your comments, Judge Albus will share those concerns with Court Operations when revising the form. Are there any comments, other comments or motions from members of the committee? Is there a motion to approve this change?
So moved, Judge Bellis.
Second, Avery Whetstone.
It's been moved and seconded. Is there any discussion on the motion? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously. And again, Judge Albus, thank you. And I would appreciate it if you would talk to Court Operations and Attorney Shea to see if the form as it's changed ultimately would accommodate the concerns that were raised by legal services.
I will do that, and thank you for supporting the rule change.
Okay, thank you. The next item is 2020-23. This is another proposed rule change from Judge Albus. He's quite prolific these days. And in all seriousness, I believe that there was a request that we put this off for 1 month so that the family section of the CBA has an opportunity to look at it. Is that correct, Attorney Del Campo?
Yes, it is, sir.
Okay, but Judge Albus, you are here. If you'd like to, understanding nothing's going to happen today, if you'd still like to frame the proposal to put it in the forefront of our minds, that would be more than appropriate.
I'd be happy to. This proposal includes numerous changes, each one relatively minor, but most of them are necessitated by the change in the family court process that we've started to implement it early because of the pandemic, but the goal always was to fully implement it starting this month, and we're doing that. And I outlined the process in my letter. I won't belabor every point, but the basic idea is for the court to set up a family court process that encourages and facilitates resolution of matters by agreement, that identifies early on in a case by calling the parties in much earlier than they typically would come in before, especially in a divorce case, to have them have an extensive meeting with family services to identify areas of agreement, likelihood of ability to reach agreement, and services that might be needed from the court, such as mediation services from family relations or evaluations and the like, and to get those started early. And then to differentiate cases based on the level of service they need and put them on different paths that are best suited for their case in terms of future scheduling. And one of the goals of the process is to eliminate the number of times parties have to come to court over the life of the case. When we had short calendar before the pandemic, as anyone who's done family law knows, there'd be a weekly or sometimes more than once weekly massive calendar where dozens and dozens of cases would be called in on the same day at the same time to deal with the motions that have been filed in the previous couple of weeks. And in cases where there were many motions, parties were often coming to court once or twice a month for the life of their case, which is very disruptive to their lives. It wasn't a very efficient way to handle the case. It took people away from their families and their jobs, and it tended in many cases to exacerbate conflict instead of try to address it and resolve it. So under the new process, we bring people in early for what we call a resolution plan date. Sometimes everything is worked out on that day and the case is finished. When it's not, it's put on a track according to a scheduling order with some preset future dates over the life of the case. And then the parties know those are the dates they're coming back to court. And if a motion is filed, it will get scheduled for their next upcoming preset date, unless it's a time-sensitive matter that can't await that date, in which case they have an opportunity to seek an earlier date. And when that date comes, the case is looked at as a whole, not just one or two motions, but the case is looked at as a whole. So a couple of impacts on the practice book, one of which was caused by COVID-19 even before we started this new process, and that is that we don't have short calendar. And as a public health matter, we probably can't, for any foreseeable time, have a calendar where a courtroom is packed with people, litigants and attorneys and the like, and cases dealt with one by one over the course of the day. So there are many references in the practice book to short calendar that don't fit reality now because of COVID and will not fit reality under our new process. Motions will still be heard, they'll still be scheduled, but there won't be an individual day where there's a calendar called the short calendar. The other general area of change concerns what we called case management under our old process. And under that process, in a divorce, for example, after the 90-day statutory waiting period had ended, the parties would have a date in court called the case management date. It was a date that was specified in the summons and automatic orders that started the case. Very often that was the first time parties came to court. They'd be expected by that date to file what's called a case management agreement, indicating what areas they had agreement in and which areas were in dispute, and proposing a schedule of discovery and other events going forward. That case management date, in effect, will become moot because we would have done all that already on the earlier date, the resolution plan date that we had called the parties in. And there already would have been a scheduling order at that time, so there won't really be a need for the case management agreement, which very often just turned out to be an exercise in paperwork that didn't have a whole lot of meaning because it came so late in the process. So the proposed new rules would eliminate the case management date and the requirement of a case management agreement, at least as we know it now. For the present time, we are still adhering to those case management dates or the concept, but we're adjusting our schedule to make the case management date fit one of the preset dates under our scheduling order. But it really isn't something that is needed or would be relevant under the new process. In the course of reviewing the rules, there were other areas where it appeared something needed updating or described a process that wasn't really used anymore. So not every single proposed change in the list that we gave is the direct product of the new process, but the bulk of it is, and most of it has to do with those two aspects of our current or our previous process. And I think it's a good idea to wait for comments from the Bar Association. I actually hope to have an informational session. I've been in touch with the president of the family law section to try to arrange an informational session for the family attorneys. I'm hoping it'll be later this month. I've given some proposed dates so that they'll have a better sense of the process too that was the trigger for these requested changes.
Thank you. Judge Bellis.
I'll be very quick. I just wonder, before we send it out to everyone, if we could just take, maybe Judge Albas could just take a quick look at the proposed revision to section 13-11, which is the request for physical and mental examination. That's contained in the civil chapter, and the practice book rule, the current practice book rule in the family chapter 25-31, which talks about discovery and depositions, does not include 13-11 as one of the civil discovery rules that are applicable to family. So I'm just wondering if that proposal, might be deleted, because I don't think it applies to family at all. I'm not, maybe somebody could take a look at it before that gets sent out, because I just don't think that should be included. But that, I could be wrong again.
All right, I'll certainly take a look at that. Thank you.
Thank you. Judge Albus, other than the family law section, there's no other stakeholders that would normally want to have a heads up on this, are there?
Well, there's the American Association of Matrimonial Lawyers, which I think has commented on rule changes in the past.
Okay.
Those are the two that I can think of that have been consulted in the past.
So Attorney Del Campo, you can get contact, if you don't have that, I'm sure Judge Albus can get you contact information for that group.
Okay. Yes, thank you.
Okay. Is there anything further on that? If not, thank you very much, Judge Albus.
Thank you for your time.
The next item is 2020-24. It's a notice from Judge Conway regarding the lifting of some of the changes that were put in place. Attorney Del Campo?
Yes, this is on December 20th, Governor Lamont issued an executive order. It was 9-0. It, among other things, lifted the suspension of the statutory and other requirements and time limits relating to appeals and offers of compromise. Section 35A21 has to do with appeals for child protection cases, and that was a provision, because it's not statutory. The judge, first the Rules Committee, and then the judges adopted on an emergency basis the suspension of that rule. What 1C does is allow the chief administrative judge in a particular area to survey the presiding judges, and with approval of the chief court administrator, that section, which is also an emergency section, allows the chief administrative judge to modify an existing rule. And what Judge Conway did by her order was basically lift the suspension that was put in place to match the lifting of the statutory suspension that Governor Lamont had put in place. You've considered this once before. Judge Albus and Judge Abrams have put in orders to lift certain portions of the suspended areas. And this is a report to the Rules Committee under 1-9C to allow you to see this. If you don't take any action on it, it will just stay in effect until further notice.
Right. And does anybody see any reason why we would be taking any action? Okay. Thank you very much. Is there any other business that the committee needs to address today? If not, I will accept a motion to adjourn.
So moved, Judge Bellis.
Is there a second?
Second, Judge Hernandez.
Seconded by Judge Hernandez. All in favor, say aye.
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 Opposed, say no. That passes unanimously, and I thank everyone for their time. Stay safe.